Would you please describe to me what voluntary resignation with good cause would be? I don't quite understand that because in this D1, we're guaranteeing those things which are reasonable, but under the case of voluntarily resigns with good cause. So he takes a new job, he has to be there, that's good cause or not good cause?
That would not constitute good cause. Good cause under this agreement is defined, beginning on page 103, as this, the city manager resigns due to, 1, the city's material breach of any provisions of this agreement, which breach is not cured by the city within 10 business days following its receipt of a notice from the city manager. The city manager says, hey, I think the city has breached my employment contract. He has to give written notice and give the city 10 days in which to correct that. If it's done, he doesn't have good cause for a voluntary resignation. The second condition is if a demand by the mayor or any member of the city council that the city manager take any action that the city manager reasonably believes to be in violation of law, ordinance, etc., would be a condition that would constitute good cause.
Okay, so the same as they're outlined earlier, it's just under a voluntary circumstance.
That is correct.
Okay, thank you very much. That clarifies that for me.
You're welcome.
So what we're looking at here is 12 months, okay, voluntary resignation under that D. If the city manager voluntarily resigns with good cause at any time during the term of this agreement, city agrees to provide city manager with a severance equal to 12 months. Any pay to which city manager may be entitled for the duration of the contract term plus 12 months of health coverage. So
If I could give you an example, Mayor, this would be the example. The amendment would set a termination date for the contract of December 31st, 2014. So if, for example, the council were to approach Mr. Baker in September of 2014 and say, we're going to exercise our right under the contract to give you notice that we're not going to renew this contract. The city would then be obligated to pay the remainder of the contract term, in other words, the next 3 months of 2014, plus the 12-month severance as outlined in D1, A through C. That's what that language would mean, and that would be the explanation for it.
does this contract bind any future council decision?
It binds the council through December 31st of 2014 at this time. Beyond that time, it is subject to further renewal based on a decision by the council to either renew or not renew the contract. At which time, if such a notice were provided to the city manager that the city wanted to renegotiate the terms of the contract, then you'd enter into negotiations. And if you reached an agreement, it would be on the basis of the new terms of the contract. Otherwise, the contract would end and any obligations required under the contract would be due and payable pursuant to the contract terms.
And hypothetically, then at the end of that contract in 2014, if there was no agreement reached by the city or the city manager, is there any obligation from the city?
The obligation would be to honor the 12-month severance portion only. There'd be no further pay at that point because the contract term had ended. And normally when you enter into a contract negotiation period, you generally hold the same benefits at the same level while you negotiate until such time as the parties simply are unable to come to a resolution, and then they separate on that basis. There's no increases, there's nothing of those kinds of things that would take place.
I'm gonna ask another hypothetical. It's for, I think it helps for the layperson, myself, to understand. Let's say the contract, there was a parting of ways, let's say, middle of next year, 2013, let's say September of 2013. What would be the city's obligation at that time?
For purposes of your question, I'm assuming that the council has asked the city manager to step aside. If that were the case, then we would go back to the voluntary resignation for good cause and apply those principles. So applying those principles as this contract is written under your hypothetical would allow for a payment from September of 2013 through December of 2014 plus an additional 12-month severance period.
And the medical benefits too?
And the medical benefits for that 12-month period. Now, having said that, let me add some additional information, because to the layman, this may sound like something that is unreasonable and not known within the industry, and that is not an accurate statement. In the public sector context of the chief administrative officers, which, for example, would be city managers, city administrators, county executives, for example, those individuals normally have employment contracts that have severance provisions in them that run anywhere from 6 months to as much as 3 years. That is dependent upon the negotiation and bargaining between the parties, obviously. But that is not unreasonable. 12 months is not an unreasonable amount of time at the level of an administrative officer for a city in the state of Oregon. I just recently did a 4-year extension for a city which extended and provided for a 2-year severance period beyond the term of the contract itself. And that was just done in the last 90 days, as an example.
And there's already an existing severance package that Mr. Baker already does have, so it's not like he doesn't have a severance package now, and this is a new one. He already has a severance package.
That is correct. There is a provision in the now existing employment contract for a severance predicated upon passage of time, years of service, and so forth.
Of course, it's our hope that out of this will come a grand relationship, and that's why we're trying to, I feel, really make it such that Mr. Baker will pursue his career here at Damascus and bring his family and come on down and let's get after this and do the job. And we're here to try and reach out and make that possible.
Without an apology by the mayor, how can that happen? I mean, if he's so